All right, listen up.
You can do more than just hear us. You can also watch us on the video feed.
Do it live
at NBC1260.com.
And good morning and welcome to Beyond the Curve, providing strategic insights on international business and international law. I'm Jeffrey O'Brien alongside my co-host, Dr. Adriana Sanford. Dr. Sanford has 6 years of law school, including a double LLM in taxation law and international comparative law from Georgetown University, a law degree from Notre Dame, and she also has a degree in political science. She's currently working on her latest degree, an executive MBA in global management. She has 4 languages under her belt: French, Spanish, Portuguese, and English. She has represented numerous multinationals, serving both as in-house and as external primary U.S. counsel. Good morning, Dr. Sanford.
Good morning, Jeffrey.
All right. Well, we have a special guest with us on the line from Washington, D.C.
We do. We have Bruce Zagaris on the line, and he has actually counseled several governments, and his area of expertise is international white-collar crime and international tax. He has served as an adjunct professor to several universities, and he recently published a book at Cambridge University. The title of the book is International White-Collar Crime.
Bruce Zagaris, are you with us?
Yes, I am.
Good morning.
Hi, how are you doing?
Good morning, Bruce.
Good. It's a pleasure to be with you.
Bruce, if you could just explain to everyone why businesses and executives should care about international white-collar crime.
Well, they should care about it for a number of reasons. When they're doing business overseas, when they're involved in international business, there's a number of laws, like U.S. laws, that apply extraterritorially or apply to international business, such as anti-corruption, international tax laws, money laundering laws, and a number of other U.S. laws. In addition, the U.S. businesses and executives have to deal with foreign laws. And although the foreign laws often are very similar to U.S. laws, they also have different laws, and of course they have their different legal culture. And then, in addition to that, there are all kinds of treaties and international laws on top of the U.S. and foreign laws. So if an executive or business is not careful, it can run afoul of any of those sets of laws. Another important reason is that sometimes an executive, by knowing international white-collar crime, might be able to use those laws for its benefit against its competitors. So, for instance, if its competitor is violating corruption laws and receives a contract that, but for the corruption, the U.S. business would have received, then the U.S. company can use international treaties and foreign laws to demand that the foreign court cancel the contract and rebid or possibly get damages against the competitor.
Right. I have a question regarding what is typically called la mordida, or facilitation fees. Sometimes, you hear that executives that are overseas are paying these additional fees in order to get the transaction going or to expedite the process. And we've had people say that, the test is a mirror test. Look at yourself in the mirror, and if you can live with yourself, it's okay. Can you tell us your thoughts on this? Well, is it ever okay to pay a mordida in another country? As a U.S. company, as a U.S. multinational.
Sure. As a U.S. company, there's a very narrow exception under the Foreign Corrupt Practices Act. If what you're doing is asking for a routine government action that would have to be done in any case, and you're just trying to get it expedited, it's legal in that other country, then it can be okay to do that. But it's such a narrow exception that many companies have an internal policy against it.
Because of the danger if they make the wrong decision.
There's a danger that it's going to be implemented in a way that's going to run afoul either of the Foreign Corrupt Practices Act or the foreign countries law, and it's a very dangerous, slippery path to go down.
Mm-hmm. What about transfer pricing abuse? Suppose you have a subsidiary overseas, a foreign sub, and you're trying to, determine whether or not your price should be higher or lower depending on the foreign exchange rate, on the taxes, whether the duties are high and whatnot. Is there a minimum or a maximum price, or is there, the arm's length transactions? Could you talk a little bit about this and the importance of having arm's length transactions when you're dealing with foreign subsidiaries?
Sure. Well, this area of the law, first of all, is very complicated. In the U.S., it's Section 482 of the Internal Revenue Code that allows the Internal Revenue Service to reallocate prices whenever they see that the company is violating the arm's length standards. In recent years, the IRS has dedicated a lot of resources to transfer pricing, as have a number of other countries. And so companies have to be very careful when they fix the intercompany pricing. And if they don't, they can even have criminal problems. Certainly, if they violate the regulations, it ends up in long, drawn-out audits.
It's not something you want to play with. You have to be careful.
No, exactly.
Yeah. Now, Bruce, are money laundering laws harder for U.S. multinationals than other foreign multinationals?
Well, I would certainly say that U.S. laws, U.S. money laundering laws, are very tough, and probably more importantly, the way that they're enforced in this country is very stringent. U.S. prosecutors are very aggressive in going after all kinds of U.S. persons, and their U.S. prosecutors are also extremely proactive when they assert extraterritorial jurisdiction. So, for instance, it just takes one email, either sending an email from the U.S. or receiving it, to constitute doing business in the U.S. for purposes of the wire fraud or mail fraud statutes, which is one of the predicate offenses for money laundering. Or, for instance, many cases are brought in New York because transactions that happen overseas are just cleared in New York. Yes, you can say that the U.S. companies have to pay particular attention to money laundering. And, one aspect that a lot of U.S. companies aren't aware of is that in 2005, the United States Supreme Court, in the Pasquantino case, ruled that an American can be guilty of money laundering for defrauding a foreign government of its revenue. So, for instance, when companies are paying agents offshore, they have to be careful that they not only don't violate the U.S. law, but they have to be careful that they don't violate the foreign criminal law, because that itself can be criminal in the United States.
Now, Bruce, tell us about the Gatekeepers Initiative.
Okay, the Gatekeepers Initiative is an anti-money laundering initiative that was started by a group called the Financial Action Task Force on Anti-Money Laundering, which is a informal group that was created in 1989. It's based in Paris. And so it has issued 40 anti-money laundering recommendations. And one of them applies, or several of them actually, apply to the so-called gatekeepers. They are, the regulations apply, of course, to banks and financial institutions. But what happened was, in 2003, they started applying to the so-called gatekeepers, who are lawyers, accountants, real estate brokers, and other people that are intermediaries dealing with money. And so essentially the Financial Action Task Force recommendations say that gatekeepers also have to follow anti-money laundering. They have to know their client. They have to be careful to identify and report suspicious transactions, and so forth.
Right. So there's actually liability on several different angles. I mean, there's so many different laws out there and regulations that you really have to be careful as an executive, as well as if you are an attorney or an accountant. And it's not an easy path.
That's right. I mean, and that is equally true if you're either in the private sector, I mean, in your own private practice, or even if you're working for a company or even a nonprofit organization. All of these laws apply to you.
Bruce has actually counseled governments on issues relating to these topics, or
exactly, because one of the things that has been in the news, you had the G20 summit in Cannes, France, and at that summit, the declaration on November 5th set forth some additional requirements that governments must meet, having to do with having more transparency in their tax systems and being able to exchange information to cooperate with other governments. And they're also required to do more in terms of anti-money laundering. And the way that the G20 goes about doing this is it evaluates compliance by different governments, and they publicize the reports. And so, for instance, just a few weeks ago, the Financial Action Task Force did a publication where they identified that some countries, such as Argentina, still have major problems in their money laundering, their anti-money laundering regime. And as a result, in the United States, right away, Treasury issued a notice telling U.S. banks and financial institutions that, look, FATF has just put a report out on Argentina, and that requires U.S. banks and financial institutions to pay what's called enhanced due diligence on any financial transactions coming from or going to Argentina. And so that's also, these evaluations are a way of trying to incentivize governments to comply with international standards in terms of anti-money laundering and corporate transparency and tax transparency.
I think this topic is fascinating, and I think anybody interested in this should definitely they can subscribe to the International Enforcement Law Reporter and get monthly updates.
That's right. Well, there's a monthly hard copy, and there's 3 or 4 weekly electronic versions.
All right, thank you. That's Bruce Segaris from the International Enforcement Law Reporter. Look forward to having you with us again sometime.
Hey, thank you very much. All the best, you guys.
Thank you, Bruce.
And if you want more on this, you can go ahead and check out Bruce Segaris' book, International White Collar Crime, or subscribe to the International Enforcement Law Reporter for the latest on international law topics. We'll be back with more on money laundering in just a moment. This is Beyond the Curve, providing strategic insights on international business and international law. We'll be right back after this.
You're listening to NBC 1260.